Planning for your child's future. Estate planning for your family. Your estate is all of your property and possessions, also referred to as your assets. They include investments, furniture, household items, real estate, jewelry, and any other items of value. Estate planning involves how you want those items distributed after your death, as well as any action you'd like to occur at that time, such as a specific level of care for your child with special needs. Estate planning also involves protecting your ability to make wise decisions for yourself and for your family while you're still alive to make them. Going through the estate planning process may be awkward and uncomfortable. It's hard to fast forward through your life and plan for a time when you will no longer be here. There are two categories of assets to consider when planning your estate. The first are probate assets, or the assets listed in and controlled by your will. Probate assets transfer to your heirs according to the instructions you made in your will. The second type of assets are non-probate assets, such as life insurance or proceeds from an individual retirement account, among others, that transfer to your beneficiaries according to the terms of the contract, not by the instructions you made in your will. How to legally transfer assets to your child without jeopardizing government benefits. In order for your child to remain eligible for government benefits as of 2018, he or she may never own more than $2,000 in assets. And that is the federal requirement. States are allowed to impose a stricter requirement. That means states can require an asset amount less than $2,000. To maintain your child's eligibility for government benefits, do not name your child with special needs as an heir in your will, or as a beneficiary of a financial contract. Rather, name your child's special needs trust as an heir in your will, or as a beneficiary in your financial contracts. Why estate planning is so important. The day-to-day activities in caring for your family may make estate planning seem like one of those things you know you need to do and will get to later, but it is important not to put it off for too long. While thinking about estate planning, consider the following. If you were to suddenly become unable to care for your child with special needs, who could step in and care for your child the way you do? If your savings had to be spent on your own sudden illness, how would that affect the long-term financial well-being of your child? What if you weren't able to prevent someone from naming your child as a beneficiary of an investment rather than your child's special needs trust, potentially disqualifying your child from government benefits? The steps you take for estate planning will help you find answers to the question, who will take care of my child when I can't? What you do when you make an estate plan. As you're about to learn, making an estate plan involves doing several things. The end result from all this planning is protection of your child's long-term ability to receive important government benefits, your ability to make important decisions about the future for you, your family, and your child with special needs, the way your estate, your property, and possessions is distributed among your family members in ways that provide them with the greatest benefits. The majority of your work in estate planning is preparing legal documents that will provide the protections that have just been mentioned. You'll also select the people who will help you prepare those documents and carry out or execute the plans you've stated in them. You can learn more about the steps needed to create an estate plan in the Creating an Estate Plan handout included in this training module. Letter of Intent. A letter of intent document becomes part of the Special Needs Trust. It's not a legal document. You write it to the person who will care for your child when you are unable to or after your death. Its purpose is to explain in detail the care you so lovingly give now to your child, so the caregiver can later walk in your shoes as best as they can. Since the nature of your child's care changes over the years, you need to update your letter of intent each year. You can find out more specifics about what to include in your letter of intent in the Letter of Intent handout included in this training module. Able Tennessee account. Tennessee Achieving a Better Life Experience, ABLE Tennessee, is a savings program designed to help Tennessee residents with disabilities put aside money to pay for qualified expenses. These accounts provide the opportunity to save and invest with tax-free earnings to help participants maintain independence and quality of life. For more information, see the Able Tennessee handout found in this module. Special Needs Trust. A special needs trust can be your main savings tool for your child's future. It allows you to transfer savings to your child without jeopardizing his or her ability to receive government benefits. It also provides a way for you to add to government benefits such as Medicaid and Supplemental Security Income, or SSI. You can set up a trust that can be active while you're alive or become active after your death. In order to set up a trust, you must first choose a trustee or someone you trust and can properly manage money. If the trust is active while you're alive, the trustee distributes money from the trust to your child in ways that don't disqualify your child from government benefits. If the trust is active after your death, the trustee facilitates the transfer of money from your estate into the trust and then helps manage and distribute the money according to your wishes. The most important benefits of the trust are maintaining your child's financial well-being and his or her long-term eligibility for government assistance. It has another benefit, though. Through this trust, friends and family can make gifts of money, also contributing to the financial well-being of your child. Guardianship. When your child turns the age of majority, which is 18 in most states, you are no longer his or her legal guardian, even if they live at home and are unable to make informed decisions. Conservatorship is a legal arrangement in which you or a trusted adult you select is given the right to make decisions for your child. Conservatorship is a court-appointed and managed role. In legal terms, your child would be considered a ward of the guardian. A conservatorship of the person will let the guardian make necessary decisions about things such as shelter, clothing, medical care, food, and so on. A conservatorship of the estate would allow the guardian to manage your child's finances and all the records that go with them, such as the Special Needs Trust. Living Will. A living will is a legal document that provides family members, caregivers, and medical professionals instructions on what type of medical treatment you want should you be unable to request it yourself. Often, living wills come into play when one becomes terminally ill or permanently unconscious, or does not care to have advanced life-saving treatments to continue these conditions. The living will includes a power of attorney, the person you select to make medical decisions on your behalf should you be unable to. Similar to selecting a trustee, you want to select a power of attorney whom you completely trust, someone who is aligned with your values and life philosophy. Will. A will is a legal document that specifies how you want your property and possessions distributed to your beneficiaries after your death. Without a will, the courts would decide who gets what. Parents of children with disabilities who need government services should not name their children as an heir. Doing so may disqualify them from receiving government benefits.